Hey, welcome, good friends of the good Lori. Welcome and happy Friday, TGIF. Boy, do we have a bit to talk about tonight. Usually on Friday nights. Oh, and welcome to Children of Darkness and Light. I am your host, Lori Hellis, also known as the Good Lori. And tonight's program is generally dedicated to talking about all things Vallow Daybell because I'm writing a book about the case. And so for those of you who haven't followed our channel before and are just joining us, welcome. I'm a retired criminal attorney with 27 years of experience, retired and writing books. So we have a lot to talk about. Not only do we have Vallow Daybell developments to talk about, but we also have a lot to talk about because the Murdoch trial is going on. And I know that there are plenty of you who are absolutely dying to talk about that as well. So we're going to talk a little bit about that today as well. Welcome to the folks that are joining the chat. And I want to start by talking a little bit about the things that have been going on in the Vallow case. There's some interesting motions and some back and forth going on that really looks very pre-trial preparation. And so the one thing that I observed as I was thinking about this is we've heard that there was an offer on the table, a plea offer on the table. But it does not sound like either one of them are prepared to take a plea. And it sounds from the way that things are being filed and things that are going on that we're headed full steam ahead for trial. So there are some interesting motions out there, some that are kind of, sort of typical, not surprising that they're going on. And then there's a couple that are like, so we can talk about those. One of the interesting, now we know that the motion to dismiss for lack of speedy trial is still on the table. There's a hearing coming up on the 9th, that's next week, having to do with all of those outstanding motions. One of the motions that's kind of interesting is, well, let me get back to the motion to dismiss before I get too fractured. The motion to dismiss, the state has filed a response saying that they don't believe that that one of the things that the defense has said is that we have to go all the way back to when Lori was arrested in Hawaii. The prosecution says, no, that's not right because they were different charges. I think they're right on that. And I think that we really, the proper date to start talking about whether or not there's been a violation of speedy trial is her arraignment in April of 2022. So she was arraigned in April, and her lawyers say that they believe that she should have gone to trial. This is bugging me. She should have gone to trial by the 21st of February. The prosecution says they think it's the 18th. Either way, we're talking about, a leeway of a few days. So the issue is in Idaho, part of the statute says that the judge can extend that speedy trial period for good cause. So now we have to figure out what is good cause. I think that the judge is going to find that there are two things that impacted her trial. If she had gone to trial in January, as we were scheduled, it would have been within her speedy trial window. So I think there's two things that the judge has to consider. Now, we've talked before about the fact that you cannot hold a delay based on competency against a defendant, but I think it does come into play when we're talking about that period from mid to late September until November, when the trial was delayed, the trial date was vacated, and the case was stayed while she had another mental health evaluation. So we learned a couple of interesting things from the documents that we didn't know before, and I'll talk about those in a minute. But I think that the court judge is going to say that the delay was because, for good cause, was because the case had to be stayed because of the question of her competency. So that, coupled with the fact that the court then had to negotiate time with Ada County in order to get it on their trial docket, I think those two things taken together, the judge is going to say there's good cause. Now, obviously, this is going to be a ruling from the court that's going to be appealed. It's going to be appealed post-trial, and we'll just have to see what the Idaho Supreme Court says about that. From what I have seen from case law, it seems to me like good cause for a reasonably short amount of delay is permitted. So my feeling is the judge is going to deny the motion to dismiss. We're going to go forward with trial in April, and then he's going to let the Idaho Supreme Court sort it out. So there have been a couple of very interesting documents that have been filed that we could talk about. One of them is that the state filed a motion in limine. Now, we've heard about motions in limine when we talked about the Murdoch case, because the state filed a motion in limine having to do with bringing in financial information. And the judge said, rightly so, a motion in limine is a motion to limit evidence, to have the judge make an evidentiary ruling to limit the introduction of evidence. It is not a motion to allow the admission. That has to be done at the time of trial. So the motion in limine that was filed in the Vallow case was filed in the prosecution's behalf. So you might recall that 90 days before the trial date, the Lori Vallow's attorneys filed a notice saying that they did not intend to bring any mental health testimony in at the guilt and innocence phase. Now, Idaho doesn't allow the insanity defense, kind of. So in a lot of states, an insanity defense is what's called an affirmative defense, meaning like self-defense or several other defenses that someone can bring, saying, here's the reason why I'm not responsible. I'm not culpable for the crime. I was doing it in self-defense. I was defending my family. It was necessary. I had to do it. I was not responsible for my actions because of a mental disease or defect. Those are affirmative defenses. Idaho doesn't have that. So we don't, in Idaho, you don't get out of being culpable for a crime because you were mentally ill. But Idaho does leave that door open, because in order to convict someone on a crime, you have to convict that person of every element of the crime as it's defined in the statute. And one of the elements of the crime is a mental state, that you have to knowingly, intentionally, whatever the designated mental state is, you have to knowingly, intentionally, recklessly, those are all mental states that are used in statutes. So in this case, if you have a client who is so mentally incapacitated that they can't form the mental state to commit the crime, then you still have a door open to bring in mental health issues. So Lori's attorney said, we're not going to bring in mental health issues. We're not going to offer any experts. We're not going to raise the issue of mental health. Lori doesn't want to do that. Now, I'm pretty sure that her attorneys probably said to her, don't close this door. But Lori decided that she does not want that raised. So they filed the notice in proper time. They filed the notice saying, we don't intend to bring that up. So now the prosecution has said, that's great, but we don't want to rely strictly on that. We want the judge to issue a limiting instruction saying that you cannot bring in mental health issues as a way to attack mental state. And it was kind of interesting because the defense's response was sort of a non-response. They kind of said, well, clearly we've got all this information that indicates that she has mental illness. And so we think it's going to come up at trial. And, they're sort of like, gee, if it comes up at trial, then, we shouldn't be blamed for it. And the prosecution is saying, we want a limiting instruction that says you can't open the door. So opening the door is a legal concept. And I think you've heard quite a bit about it if you're following Murdoch, about the issue of whether or not by eliciting testimony that the other side may have opened the door to a line of examination that they wouldn't have been allowed to go into otherwise. So, for example, in the Murdoch case, they're talking about, well, they brought his character into it, saying he was a loving father, he was a great dad, he was a loving husband, he was a devoted attorney. And I mean, they have put his character at issue. So the state in that case is saying, now that his character's at issue, we should be able to bring in all of these bad acts to show that he was dishonest, that he didn't care about who he hurt, he didn't care about other people's feelings, he was bent on getting what he wanted, and painting this entirely opposite picture of him. So in the Vallow case, the prosecution is saying, we want a limiting instruction that says nobody can open the door on the issue of Lori's mental health. So that will be interesting to see what the judge rules next week. There are a couple of other interesting things going on. The prosecution has subpoenaed Lori and Chad's temple and church records. Well, I think they've only subpoenaed Lori's. We don't know why. We don't know if that's to prove she was somewhere when she said she wasn't, or vice versa. We don't know. We also don't know why they have subpoenaed all of JJ's education records from Arizona, from his school in Arizona. So those are a couple things that we've seen in the records. We're not really sure why they've done it. Every time we have a hearing these days, the judge is going to be sort of knocking down some of that and narrowing things so that when we do get to trial, we're going to have a narrower focus on how the prosecution goes forward, how the defense raises reasonable doubt. So very interesting, this waiting period. The other thing that has been going on in the background, and we've seen some documents and some sealed proceedings with the court, is the issue of jury selection. Because we are seeing all of these sort of pre-trial things ramp up, it seems pretty apparent that neither of them are going to take a plea. I mean, it's not impossible. They can take a plea right up until trial or during trial. But the more preparation that goes into it, the more you start to wonder, well, maybe they're not going to, maybe they've turned down the plea. So one of the things that we're seeing a lot of flurries of activity, and some of it is being sealed for obvious reasons, having to do with jury selection, with the questions that are going to be asked to the jury, the information that's going to be given to the jury in advance. So in every jury, when a jury comes in, the judge gives some introductory kinds of information, instruction. Then they go through jury selection, and then the judge continues to instruct the jury on what comes next and what the rules are for how juries conduct themselves. And then once the trial starts, the judge has some preliminary remarks to make, and then jury instructions are given again. The judge instructs the jury on the law at the end of the trial. And most of those jury instructions are standardized. So most states have a set of uniform jury instructions that are generally accepted. If a lawyer wants to give a different instruction or wants the court to change wording in a standard instruction, the lawyer has to convince the judge that of the reason why, and then has to ask the judge who rules on whether or not he or she will give that instruction. So once the jury comes in, they fill out a jury questionnaire, a lot of demographic information. They will be asked in their jury questionnaires a lot of very straightforward questions, such as, do you have health problems that would keep you from spending 10 weeks on this jury? Do you have other responsibilities? Say, are you responsible for a minor child or an aging parent or somebody else who you're a caregiver for that you can't be away from? Are you impaired in some way? Can you read? Can you write? Can you hear? Can you see? So that you can actively participate in the case. And then the questions will begin, because what's going to happen is they're going to try and weed out those people who it's simple. They can't be available, or they're ill, or they're undergoing chemo, or they're deaf, or any number of things. And then they will sort of shrink the pool down to people who have answered their jury questionnaires in ways that they're qualified and available. Then they will start talking at length about what the case involves, the fact that it is a death penalty case, and questions about whether or not people are opposed to the death penalty, whether or not they could impose the death penalty because it's the law of the land, whether or not they are have heard a lot about the case and formed an opinion. Now, just because someone has heard about the Vallow case doesn't mean that they can't sit on the jury. We're not looking for a jury of people who have never heard a thing about the case. We are looking for a jury of people who say, either I haven't formed an opinion yet, or I can set aside what I've heard about it so far and render an opinion based on the information that I hear at trial. So the next thing that happens is each of the sides are allowed a certain number of first of all, what happens is each side is going to say to the judge, if there is cause, if there's some specific prejudice or cause for a juror to be dismissed, then that's the first round. Once that happens, then each side will be allowed peremptory challenges. And those challenges, you don't have to say why. You just bounce a juror because you formed an opinion about them. It could be because you feel like they're too conservative and that they might err on the side of believing that if the prosecution brought the case, they must be guilty. Many things go into that whole. I mean, there are people who make their living being jury consultants. And sort of reading the tea leaves or running the Ouija board and trying to figure out who the best jurors will be. I've always been of the opinion that if you have jurors who say, no, I haven't formed an opinion, yes, I can be fair, that there's not really that much that goes beyond that. But there are a lot of lawyers who feel like picking a jury is sort of like a part Ouija board and part science. So, and there are lawyers who delve deeply into picking juries. There are a lot of studies out there that would suggest that they don't do any better. They don't have any better win-loss records than people who say, I'll take the first 12 qualified jurors. Now, this is going to be a long case, and I expect that the judge is going to appoint and pick ample alternatives, alternate jurors, because jurors do drop out, get sick, have family emergencies, things happen. And in a long case like that, it easily can happen. So I think we're going to see at least 6 and maybe more juror alternatives in the Vallow day bail case. Now, Murdoch is being tried in a small town, in a small community very small community where everybody knows everybody, more like Rexburg than like Boise. And they have been able to seat a jury in spite of that. So I think it's possible. And I think that it will be interesting to see what comes of that trial as they go forward. But I think there's every opportunity here in Boise to be able to seat a fair and unbiased jury. So I expect they're going to go forward, and I don't know that jury selection is going to take as long as they've allotted for it. I think it will take, like it did in Murdoch, 3 to 4 days at the most. They've sort of set aside the prosecution has said 2 weeks. I think that's grossly exaggerated. So let's talk about Murdoch. We got a few minutes and then I'll take some questions. I always like to chat first and then take questions the second half. So I do want to talk a little bit about Murdoch and what we know and what we've heard so far. Very interesting. While you are thinking about formulating questions, please put them in the chat. Start it out with the word question so our moderators can catch it. And if you have posted a question while we've been chatting, you might want to repeat it just because it's a little hard for them to catch them because our chat moves. So if you don't see your question coming up, repost it. So Murdoch is fascinating. The first week, we saw an awful lot of very dry entries having to do with just teeing it up, putting the evidence into the record. So we got interviews and bullets and crime scene, and it was very disturbing, but a lot of it was pretty rote. Your Honor, I want to offer this. It's received. That sort of back and forth, that can put you to sleep. So, but this week, we have seen some really fascinating and potentially explosive information. So I think one of the things that I will get to you all this weekend is I've been taking copious notes on the phones and keeping up with. So I've made a little chart. It's nothing fancy, but it does sort of outline the timelines of events on each phone. I think it's very interesting that Elick, so down in the South, they pronounce Alex as Elick, like E-L-I-C-K, Elick, and they pronounce Murdoch. So Elick's phone, when the murders happened, of course, law enforcement seized both Paul and Maggie's phones. Maggie's phone was tossed out of a car half a mile down the road, and funnily enough, Find My iPhone zoomed right in on it, and law enforcement were able to find it the next day. So they had both Paul and Maggie's phones. It wasn't until months later, the murders happened in June, it wasn't until September that they actually got a hold of Elick's phone and did the extraction and downloaded it. And during that time, his phone calls from June 4th through the night of June 7th were all wiped out of his phone log. And that's something you can do manually just by going to your phone log, and they were all iPhones, swiping and deleting all those calls. Now, it doesn't delete the call at the other end. So Maggie's phone indicated that those incoming calls had come in and been unanswered, but he deleted them, which is kind of interesting. The other thing is that at the time that he said to law enforcement, I never went down to the kennels, I was at the house, I took a nap, I then told Maggie I was going to go check in on my mom, and I was never at the kennels until I found the bodies. And then this video surfaces that Paul has made with Elick in the background. There's two videos. The first one is a Snapchat video that Paul made a little bit earlier in the day, 7:50, so not that much earlier, where they're talking about trees that they planted that weren't doing well. And then by 8:49, they're all at the kennels, and you can hear Paul has a friend, you heard from him, Rogan, whose dog was at the kennel, was at the Murdoch kennel, and Paul was concerned that there was something wrong with the dog's tail, that it had been injured, and he was trying to get a video of it. And there in the background, you can hear Maggie and Elick. And so that totally negates the fact that he wasn't there. Not only that, but it's just seconds, just less than a minute after he creates that video that he's going to send to his friend Rogan, which he never sends. And it's just less than a minute before both their phones lock and never open again. So, and Elick was there. Clearly, he was there. You can hear his voice. So the other interesting thing is that on the earlier Snapchat, he's wearing different clothes. So he's somewhere along the way, he changed clothes. Nobody knows where those clothes are. And his house was not searched until much later. This is because the first thing that happened was the area down along the dog kennels was crawling, of course, with law enforcement. But the first thing that happened was Elliot called family. He called his law partners, and the place was crawling with law partners. There were 5 or 6 lawyers on the scene as the investigation, as the law enforcement were trying to do the investigation. The place was crawling with lawyers. So I think they were very careful, and they remember that the Murdaugh family is incredibly powerful family. The patriarch, who was the power broker in the family, was on his deathbed and actually died 2 days later. But nonetheless, this is a family that had a reputation for being incredibly powerful. So law enforcement were treading very carefully, particularly since half the damn law firm was there on the scene as they were conducting their investigation. So we know that he changed his clothes. We know he lied about being at the dog kennel. We know all of those things, that all this circumstantial evidence that points to him killing his wife and son. What we don't know is why. Now, you'll hear time and time again lawyers say, I don't have to prove motive. I don't have to prove. All I have to prove is that he did the elements of the crime as they're laid out, that it happened in our jurisdiction, that he did XYZ, and it resulted in the death of these 2 people. I don't have to prove motive. But juries are human, and they're going to sit there and they're going to look at this guy who they know is this well-connected, seemingly wealthy person and say, how could he murder his son and his wife? Why would he do that? Why? We all want to know why. I'm writing a book about the Vallow case because I want to know why. So we all want to know why. Jurors want to know why. So even though the prosecution can stand up and say, I don't have to give you a reason why. I don't have to prove motive. All I have to prove is that he did it. Human nature being what it is, the jury is going to say, maybe the fact that I can't figure out a why raises reasonable doubt for me. So the prosecution has said, and their theory, which makes sense, and I hope this is how it's going to be argued, it sure would be if it were me, is that the pressure that he was under because of all of the financial crimes and the financial misdealing was enough to tip him over and to have him commit these crimes because he believed that it would get him sympathy. So here's the really pivotal piece. The judge, the defense lawyers said, we don't want any of that information to come in because we think that it is prior bad acts information or character evidence that is going to, that they're trying to bring it in to prove he's a bad guy and so he must have done this crime. Now, the prosecution's saying, no, we're bringing it in because we feel like it shows his motive. So most of yesterday afternoon and part of today, they had an in-camera hearing. In-camera means in chambers or outside the jury's view. The reason for that was to put on the evidence and let the judge decide whether or not it was relevant, probative, not prejudicial, or not more prejudicial than probative, and whether or not it was being offered to prove motive. So here's the narrative, which I really hope that the prosecution is going to be able to sum up and give the judge a little bit of a roadmap. Certainly, I think this is where they're going when this information gets presented to the jury. So they gave us a snapshot of all of this financial misdealing that was going on. Up until this recent occurrence with his good friend, Chris Wilson, all of Alec's dealings, his thievery had been from misdirecting client money. So it's important to understand from the standpoint of lawyer ethics and state bar associations and all of those things. Lawyer trust accounts are absolutely sacred. Lawyer trust account is money that you hold for the benefit of your client. It's not your money. You haven't earned it. It's in that fund either because you've been paid a retainer that you're holding until you earn it with work, or it's money that has come in for the benefit of your client in a form of a settlement. So what happened, to set this all up, I'll try and be quick about it, is that Alec and Chris Wilson, who have been very good friends for a long time, did a personal injury case that included a products liability claim. And they got a big settlement. And so there were 3 lawyers involved. The primary lawyer who had brought the case to Chris, who then went to Alec because Alec's firm had experience with product liability, got a bigger percentage of the attorney fees. But Chris and Alec both got $792,000 or $91,000 in attorney fees. Now they had the financial officer from the law firm who came and explained how people are paid in the law firm. Essentially, they all receive an annual salary. And then at the end of the year, the company sits down and figures out how to divide anything above their salaries in a big end of year bonus to close out the books by the end of the year. And this can be 6, even 7 figures worth of money, and had been historically for Alec. So what happens anytime attorney fees are earned, they go into the operating budget, they go into the income account for the firm. They're not paid directly and individually to the attorney. So the law firm is concerned because they don't want it to appear that they're helping Alec hide money because of the boat crash lawsuit, because he was being sued. And they're kind of treading cautiously. So Alec gets this $792,000 and he goes to his friend Chris and he says, the first thing that happens is the firm says, we can't find that money. It didn't come into us. And so they reach out to Chris, and Chris's assistant says that money's been dispersed. Our bosses both got checks. So now that's a problem. So the whole time, Alec is telling his firm the money's in Chris's trust account. And I've asked him to hold it because I don't want it paid out until I figure out how to structure things for my wife because of the boat crash. So the firm's not happy about that, but Alec is talking about putting the money into a annuity of some kind that would create income for his wife. It's very complicated. It's very convoluted. But the bottom line is he has to go back and put that money back into Chris Wilson's trust account to prove to the firm that it was there, even though he'd already taken it. So now you're monkeying around with trust accounts, which is not a good thing. The morning of the murders, the CFO of the company sits down with Alec. Now, she has been asking him about this money for weeks. She sits down with him and says, I need to have a little come to Jesus with you about this money, because I've got to figure this out. We've got to account for this money. It should have been paid to the firm. It wasn't paid to the firm. I need to get that money from Chris's trust account, and it needs to be paid in. Well, in the meantime, Alec has run around, gotten a bunch of loans to pay back all that money into Chris's, almost all the money into Chris's trust account. So she's sitting in his office. This is the argument that I think the prosecution really needs to focus in on. She is sitting in his office when he takes a phone call, and it is a family member telling him that his father, Randolph, who had also been a member of the firm, was not expected to live. He was back in the hospital. There wasn't much more they could do for him, and he wasn't expected to live. And he imparts that information to this woman who's worked for 20 plus years for this firm that's like a big family. And she promptly drops the discussion about the missing money and becomes very solicitous and wants to know how they can help. And he ends the discussion and leaves. She thinks he's gone to tend to his father. She finds out later he's still in the office somewhere. But I think the prosecution needs to argue that was the moment when Alec understood that a family crisis was going to get him leeway. He couldn't be sure how soon Randolph was going to die. Now, it turned out Randolph died 3 days later, but he could not be sure that Randolph was going to die. But that was the moment that he thought, wait a minute, I can get some leeway. I can get all of these folks off my back until I get everything moved around and rob Peter to pay Paul to get this right so that I don't get caught. I can do that. I can get them all to back off if there's a family crisis. Just my dad being ill and in the hospital got them to back off this much. Imagine what would happen if there was a death in the family, an unexpected death in the family. I think that is where he formed the idea. I think that's where that came from, where he said, if my dad going in the hospital and them saying he's not really expected to hold on much longer is enough to keep her off my back, imagine what would happen if there was something bigger. And I think that that's when he formulated his plan. And I think that's where the prosecution is going with all of this financial information. So the question is Judge Nelson going to allow that to come in? And I think he is. I think I think just from body language and from the questions he's asked, I think he is going to let it in. I think, first of all, because the other side has opened the door to Alec's character by talking about his, what a great loving father and loving husband he was. And so I think they've opened the door. Now, what that means is all that testimony that happened outside the view of the jury is going to have to be repeated for the jury. So you've got another couple days of very detailed financial information coming in before we really wrap this trial up. So it's fascinating. It's very interesting, complicated case. And it's been really interesting to watch. So before we get started on questions, I just want to remind you all, I want to thank everybody who has subscribed this week. I mean, we're getting 100 or 200 new subscribers a week. And I want to encourage people, hit the button, hit the bell, hit the like button because it helps us with the algorithm. Also, hit this bell to get notifications, because as the Vallow trial gets closer, we're going to be popping in with doing some YouTube shorts. Once we're at the trial, I'm going to be doing a boatload of those YouTube shorts to keep everybody advised as to what's going on, particularly if there's no cameras in the courtroom, because I'm going to have to be your eyes and ears in the courtroom, and I will be. So let's take some questions. Maureen Guichard. I think I'd be able to pronounce that. Question: do you think the judge in the Murdaugh trial will allow the financial shenanigans in for the jury to hear? Yeah, I think he's going to. I think he's going to find that the other side opened the door for character evidence to come in. And I think he's going to find that it goes to like Murdaugh's motive. And I think really significantly that whole confrontation earlier in the day with the law firm being interrupted by the information that his father was ill and going in the hospital again, and that buying him that big amount of grace. I think that's what convinced him that he needed to do it. Silly me. I think Lori Vallow's alibi is full of holes. Oh, no question. How does she know the children were killed in Alex's apartment? Why didn't Lori report the murders? Why did she run or try and hide from police? So many questions. And silly me, you are absolutely right. The defense is required to provide notice that they are going to use alibi evidence, just like they're required to give notice of the mental health intents or non-intention. So the defense was required to file that notice or not be able to raise alibi at all. It could be very different. The alibi they raise at trial could be somewhat factually different or factually more fleshed out than what they've said in the motion. But they had to issue the notice or they wouldn't be able to bring it up. So I agree it's full of holes. I agree that we don't know how she knows that the children were killed in Alex's apartment. She certainly didn't report anything, and running and hiding is consciousness of guilt. So I agree it's full of holes. I think it was next to ludicrous what they presented. Now, what they present at trial, I don't know. That could be different. Hope you all got your wine tonight. I've been trying to limit my wine intake to Friday nights when I'm with you. Teresa Terrell, and thank you for your donation. I want to remind everybody that any Super Chat donations, any PayPal donations go directly to our moderators. And I do want to let you know that it is making a difference for them. Teresa Terrell, does jury analysis selection really happen like it does on that TV show Bull? This is embarrassing, but I've never seen Bull. I find it difficult to watch legal shows because I spend my whole time yelling, they can't do that. What are they talking about? That's not right. It's kind of like a busman's holiday. So I haven't watched it, so I don't know for sure. I would say that in larger cases, I guarantee you that there were jury gurus that were doing analysis on O.J. Simpson and some of the other big criminal trials that you can think of with wealthy people. I suspect that there will be a jury consultant that on this case because somebody's paying the bill. Anytime in large, like personal injury or product liability cases where there's millions on the line, generally they use jury consultants and analysts. To be truthful, in your run-of-the-mill state court criminal action, not so much. The attorneys sort of have a gut feeling for what they want from a jury based on what the charges are and who the defendant is, and then they move forward with it based on their own expertise. But you don't see a lot of jury consultants and analysis in state criminal court. What are examples of inculpatory and exculpatory evidence? That's a good question. Inculpatory means things that are incriminating. In the Murdaugh case, I would say inculpatory information is the fact that there's a video of Alec at the kennels, literally at the time the murders are committed. Exculpatory information could be that there are no fingerprints on any of the guns or any of the casings. So somebody asked me earlier whether I thought that was an issue, and I don't, frankly. First of all, they don't have the murder weapons. They don't have those guns. They know that the casings that were found at the scene were fired by a gun that's missing. So we know, first of all, there were 3 of those 300 blackouts. 2 were given to Paul and his older brother Buster for Christmas in 2016. Somewhere around 2018, according to Paul, he's pretty irresponsible and leaves stuff everywhere. But he said he was at a party and his 300 blackout, which was painted a tan color, was stolen and never been seen since. Nobody's ever found it. It's never turned up anywhere. Alec then bought Paul a replacement 300 blackout, and it was black. And we heard some testimony about his friends running around shooting hogs, and they always had a 300 blackout with them. Could have been Buster's, could have been Paul's. There's only one, they only found one, Buster's, that had the thermal sight on it. Beyond that, there's a missing blackout. So exculpatory evidence would be evidence that proves that the person didn't do it. One of the biggest exculpatory bits of evidence has been DNA. And in cases like, I can't think of their names, the case that happened with the guy who went to prison and then was exonerated and for a rape, and then later was convicted of murder. That DNA evidence that somebody else committed the rape was exculpatory to the guy who'd been convicted because it showed that he couldn't have committed the crime. So inculpatory means things that are incriminating. Exculpatory means things that prove that you didn't do it. So, exculpatory evidence could be if they were to find the gun and find somebody else's fingerprints on it. That would be exculpatory information. Right now, nobody knows where the 2 murder weapons are. The only thing we know is that Alec showed up at his mother's house with a bundle, what the housekeeper said she thought was a blue tarp, what everyone thinks was a blue raincoat, and inside of it was gunshot residue. So obviously he had the guns wrapped up in that coat. Where the guns are, nobody knows. There's a juicy rumor going around that they're buried with Grandpa Randolph. So who knows? Hi, Trisha the trucker. I love when I hear from Trisha. First of all, I come from a trucking family. In fact, my first father-in-law invented the 5th wheel trailer hitch, which will make Trisha the trucker go, ooh. And I come from that trucking background family. So I always love hearing from Trisha. Indiana tonight. Hope the weather's not too terrible. So when I'm just going to preface my answer to Trisha's question by saying that in the interview, one of the police interviews that Alec did, which shows up on on a body cam, he says he's talking about the scene. And he makes a statement which some people have interpreted as a spontaneous confession or a spontaneous consciousness of guilt. He's talking about the horrendous scene, and I don't want to get too far into this because I don't want to get demonetized, and I don't want YouTube to pull our video, but he's talking about the horrendous scene around Paul. And Paul was murdered with a shotgun blast to the head, and it was awful. And some people have said they hear him say, it was so bad, I did him bad. And some people say, they have heard him say, it's so bad, they did him bad. And I think it is really going to be is this dress gold or gray or whatever that thing was on the internet. In listening to it slowed down, it still sounded to me like he said I, and I think that is what the prosecution is going to say, that in this moment of being very emotional, he inadvertently made that statement, and it is an excited utterance, a confession of the crime. I heard it as I. Talking to my friend Gigi, she said she heard they. So, I think it really is going to come down to what the jury hears. I think each side is going to argue their position, but it really is going to come down to what the jury thinks they heard. Is it critical? I don't know that it's a critical piece. Circumstantial evidence is a chain, and you have to link the chain together. So is it a link in the chain? Absolutely, it's a link in the chain. Just like the fact that the gun, just like the fact that the 300 blackout shells, that the brass around Maggie had been circulated through one of the family guns. Just like the fact that Alec was on a video seconds before the murders. All of those things create this chain of circumstantial evidence that becomes the evidence in the case. So I think it's another piece of circumstantial evidence. I'm not sure that it is in itself very important. I think there are other pieces of evidence that are much more important. And I'm glad Trisha agrees with me about the motive. I just really think that that was the moment as he was sitting there in this office and the light bulb turned on, that if he got bad enough news, they'd all back off. I think that's when the light bulb turned on, that something had to happen. Now, I think there was a lot more going on. I think his marriage to Maggie wasn't that great, even though he says it was. I think there were incredible financial pressures. And the other thing is, Maggie's estate was worth about $5 million, and it included the Edisto Beach house. Alec was trying desperately to get money to use the Edisto Beach house as collateral, and Maggie was very resistant to that. She had canceled and rescheduled an appraiser coming out to appraise that property multiple times because she was suspicious that Alec was doing something fishy. So I think there was a lot more reason that he would be happy if Maggie was out of the way. I think he did not realize Paul was going to be there. I think there's been some suggestion already that he was trying to get her to come out to the farm and go with him to see his father in the hospital. That's what he told her, and she was pressuring her to do that, which is why she was at Moselle. She came to Moselle because he was putting the pressure on her to go see his dad in the hospital, which of course he never did. So, Meadow Crone. Sounds like something out of a fairy tale. Do you think the investigation was sloppy, checking house drains, etc., so that Alex would get away with murder? I don't know if it was sloppy. I think it was deferential. I think that when law enforcement looked around that scene and realized there were numerous, I don't know how many, there was a whole handful of very high-powered lawyers who were super well connected, all wandering around as they were trying to do their investigation. I think that was pretty intimidating, and I think they were deferential. I don't know that it was sloppy. I don't know that there was any I don't know that there were shortcuts taken. Certainly, crime scenes, how do I put this delicately? Crime scenes are incredibly messy. They are, and this particular crime scene was exponentially messier. So does that mean that things are going to get overlooked? Does that mean that potential evidence could be contaminated? Yeah, it does. Because you have humans moving through this scene, and it's very difficult to make sure that they're not contaminating the scene. I don't think they did, from what I heard during the trial, I don't think they did anything out of the ordinary. I don't think they did anything that wasn't typical in investigating a crime scene. So, yeah, there's a footprint from one of the police officers. This is why every officer's DNA is on file. And this is why the shoe print gal person who was doing the shoe print analysis made sure that she got every officer that was out there on the scene and took pictures of their shoes. This is why they do those sorts of things, to be sure that they can cut out any source of contamination. It's not a perfect system. And I mean, I think they would argue it doesn't have to be perfect. It can be as perfect as they can make it. But there's certainly going to be contamination. Now, the business of the house, they did not go into the house until much later. Next day, maybe even later, when they finally served the warrant in the house. Actually, what happened was they went to the house with a warrant and they were given consent to search, but the house was full of people. The house, there were probably 50 people in the house. The house was full of family, and all those darn lawyers from the firm were there again. So even though there wasn't an explicit threat to law enforcement, I'm certain that they were very deferential, because here's this family, they're all in grieving, here's all these mourning people, and they're all lawyers, and they're all very well connected, powerful, scary people. So you can see how they would defer in that kind of a situation. I think that we see a lot on TV about, oh, we found blood in the drains. I actually had a case where a person was involved in covering up a death. He was involved after the fact, and it was a case where it was a hit and run. So it was a car versus pedestrian hit and run. And after it happened, and it was bad, the car was messed up, the people that were in the car were bloody. They called this person, and he came and helped them clean up. As a result, he was covered in crime scene. He then went to a friend's house, took all of his clothes off, threw them in the dumpster, and took a shower. Later, when they discovered that he was involved and they went back and looked at this place, they found the bloody clothing, but when they tested the drains, there was no evidence of blood in the drains. He admitted he had gone and taken a shower, and still they didn't find any evidence of blood in the drains, the victim's blood. So I think it's a little far-fetched, we're checking house drains, and did he take a shower and wash off blood? Yeah, I think he did. I think he went up and changed his clothes. I think he took a shower and cleaned up and changed his clothes. And I think that, where did his clothes go? Don't know. Where did the guns go? Don't know. He had plenty of time to get rid of stuff and plenty of places to do it. Very rural area, extremely remote rural area. So who knows where all that stuff is? But I don't think that translates into law enforcement being sloppy. Yes, please subscribe to my newsletter. I generally focus the newsletter on the legal issues that are coming up in the Lori Vallow case. However, I do have a little spreadsheet that I'm going to attach to this weekend's newsletter, having to do with all the phone calls and all of the information that was extracted out of the phones in the Murdoch case. And I have addressed some of the legal issues that have come up in the Brian Koberger case. That's the University of Idaho case. So please subscribe to the newsletter and join us. I want to assure you that I don't spam your email with anything but a newsletter, and I don't put them out unless there's something interesting to talk about. But if you are interested in legal stuff and you really want to take a deep dive into the statutes and the rules and the case law, that's where I do that. I really sort of get into doing my homework, as they say. So Let's take one more question. I see a question from, well, let's take two. I see Trisha the Trucker. I'm going to pop them in here because I see it. we're playing dueling questions with my moderators. I'm messing with them. And then I see one more right below that from Mary. So we'll take that, and we'll take Mary's question last. Also, please know that when you ask a question, if your question doesn't get answered, post it in our notes below, because Saturday mornings I get up with a cup of coffee and I answer all those questions in our comments. And if you still haven't gotten your question answered, email me. The email's in our show notes, and please feel free to email me those questions. I answer every one of them. So Trisha the Trucker asks, did they ever look for or find the clothes that Alex was wearing in the Snapchat video? You know, that hasn't come out in trial, and I don't know. I think it will be interesting to figure out whether or not they have been able to locate those items of clothing. I suspect that they're wherever the guns are. And we don't know where that is, but I suspect that he took all that stuff and the guns and went to Mama's house. And I think wherever the guns are is where you'll find the clothing as well. Oh, I'm going to sneeze. Last question from Mary. I think those lawyers were messing up the crime scene on purpose. Very suspicious mind. The same at the house. Well, I don't know if they were actually messing with the crime scene as much as they were just getting in the way. And they were just lurking around and watching everything everybody was doing in a way that would be intimidating. Whether or not they actually physically were there messing with the scene, I kind of doubt, but they certainly were there being intimidating and looking over the shoulder of all the investigators. And so I think intimidating them, making them double think everything they were doing and second guess everything and perhaps not be as aggressive as they would have been had it not been the Murdaughs. I don't think there's any question that the Murdaughs got special treatment. Paul Murdaugh got special treatment in the boat case. I mean, he was never fingerprinted. His mugshot was taken on somebody's iPhone in the hospital corridor. He was never taken in and fingerprinted and photographed the way that any other person would be. And he didn't spend a minute in jail after he was charged with the boat crash. And that boat crash included the death of one of his friends. So I want to say thanks so much. These hours just fly by. I know it's because I talk fast and I try and jam too much in. I want to just say thank you for all of you, all 273 of you that are in chat today. Be sure and hit the like button. Likes count even if you watch a replay. So please be sure and hit those like buttons because it really does impact our algorithm. And as we get closer to trial and we start posting things, we're gonna scoot up in the YouTube universe. So please do that. I just want to say thanks for everybody who tuned in. I know that you have other things you could do with your Friday night. So thanks for joining us. For all those who are going to tune in on the replay tomorrow, I'll be drinking my coffee with you in the morning. So please let me know if you have comments. A couple of little housekeeping things before we end, and I know I'm running late. Don't forget, we're doing a quilt along. Here's some of the squares in our quilt along. Don't forget that. It is in our show notes, and you can quilt along with us. Beginners are welcome. I am doing little instructional videos that you can find on our channel, and all of the information to join us in quilt is in the show notes. Also, Larry Woodcock and Kay Woodcock have asked people to contact Judge Boyce and ask him to reconsider his decision about cameras in the courtroom for trial. And that address and information is also in our show notes. Lastly, I have a lovely stack of self-addressed stamped envelopes that I'll be working on this weekend to get all of you your wristbands, your Justice for JJ and Tylee wristbands. I would love to see us just flood social media with pictures of people wearing those wristbands when the trial starts. So please consider sending me a self-addressed stamped envelope. They're free, and I will send you a wristband. That's all for this evening. Join us on Wednesday for True Crime Wednesday, when we'll be talking about all things true crime, developments all over true crime. I've heard that Letitia Stout has a trial date. I've heard that there may be some developments coming in the Koberger case, some legal developments. And so please stick with us on Wednesday, and we'll all get together then to talk all things true crime. Thanks you all for joining us. I appreciate it, and we'll see you on Wednesday. Good night.